of appearance first?
Yes, thank you.
For petitioners Jason Murray, Eric Olson, and Sean Grimsley, Martha Tierney, Mario Nicholas, and Nikhil Suss.
Thank you.
Your Honor, on behalf of President Trump, we're glad to see who's here today. Myself, Scott Gessler, Jacob Roth, next to me, Jonathan Shaw, and Chris Talbot.
Jane Raskin, Mike Melito, Nathan Volker, and Robert Kitzmiller on behalf of the Republican State Central Committee.
And good morning, Your Honor. Michael Kotlarczyk on behalf of the Secretary of State, joined with Jennifer Sullivan from the Attorney General's Office and Deputy Secretary of State Christopher Beale.
Great, thank you. And thank you, Mr. Murray.
Of course. Petitioners call Professor Gerard Magliocca to the stand.
Professor Magliocca. Do you raise your right hand? Do you swear under the penalty of perjury to tell the truth, the whole truth, and nothing but the truth to this court?
I do.
Great.
Good morning, Professor. Could you introduce yourself, please?
Yes, I'm Gerard Magliocca,
How do you spell your last name?
Magliocca.
Where do you work?
I teach at the Indiana University Robert H. McKinney School of Law.
Now, you're here as an expert today. What topics are you here to testify about?
I'm here to give expert testimony on the history of Section 3 of the 14th Amendment.
How long have you been at Indiana University McKinney School of Law?
22 years.
And in those 22 years, has your scholarship had any particular focus?
Yes, I focus mainly on constitutional history.
Are you a member of any professional organizations related to constitutional history?
Yes, I'm a member of the Supreme Court Historical Society, the American Society of Legal Historians, and I'm on the board of editors of the Journal of American Constitutional History.
Can you give us a general overview of what kinds of published works you have in the area of constitutional history?
Well, I've written 5 books and something in the neighborhood of 20 law review articles on various constitutional history subjects.
Have you written any books specifically about the 14th Amendment or its history?
Yes, about 10 years ago, I wrote a biography of Congressman John Bingham, who was the main drafter of Section 1 of the 14th Amendment as a member of the Joint Committee on Reconstruction.
Have you written any academic articles or journals related to the history of the 14th Amendment?
Yes, I have 4 articles that cover different aspects of the history of Section 1, Section 2, and Section 3 of the amendment.
Do you have any other articles about 19th century history?
Well, yes, several. I mean, some of them cover the period of Jacksonian democracy. Some cover the period in the late 19th century, sort of around the populist period or the Gilded Age, and others of my books also focus on different aspects of those subjects.
You mentioned that you've written on the subject of Section 3 of the 14th Amendment. Tell us about that.
Yes, so in 2020, I drafted a paper on Section 3, and that paper was posted to the Social Science Research Network, which is the place where professors post their draft papers to share with the public, in December of 2020.
Was that later published?
Yes, that was published in 2021 in Constitutional Commentary, which is a peer-reviewed journal run out of the University of Minnesota.
Before you posted your article about Section 3 on SSRN in December of 2020, give us a sense of the state of the existing scholarship on Section 3 of the 14th Amendment.
There really wasn't any.
How, if at all, has that changed since then?
Well, it's changed quite a bit, especially in the last few months.
Have you written any other articles about Section 3?
Yes, I have a draft paper that is going to be coming out in the Journal of Constitutional History, or Constitutional Law, that is kind of run out of the University of Pennsylvania. That was given as a talk at a symposium in January on the 14th Amendment.
Can you tell us whether any of your work on Section 3 has ever been cited by courts?
Yes, my original article was cited by the United States Court of Appeals for the Fourth Circuit, as well as a federal district court in Georgia.
Has your work on Section 3 ever been cited by any government agencies?
Yes, the Congressional Research Service cited the article in an analysis of Section 3 that they did.
Have you ever given expert testimony on Section 3 of the 14th Amendment?
Yes, I have. I gave expert testimony on the history of the amendment in an administrative proceeding in Georgia that was addressing the eligibility of Representative Taylor Greene.
I want to pull up Petitioner's Exhibit 162. What is this?
This is my CV.
Is it current?
Yes.
I don't want to talk about every entry here, but just briefly, can you summarize your educational background for us?
Yes, I received my undergraduate degree from Stanford and my law degree from Yale.
If we go to the second page, just tell us briefly which of the books on your CV relate to 19th century history or constitutional history.
All 5 of the ones that have been published.
And is this entry here the biography you were referring to about John Bingham?
Yes, it is.
And if we go down to book chapters, law review articles, and essays, we see a few entries related to Section 3 of the 14th Amendment. Were those the forthcoming article and the previously published article that you mentioned earlier?
Yes.
And briefly on page 4, can you just highlight for us on this page of your CV some of the articles here that relate to 19th century history or the history of the 14th Amendment?
Sure. The one at the top is about Section 2 of the 14th Amendment. Then also the one, let's see, going down a little bit. Okay, why did the incorporation of the Bill of Rights fail in the late 19th century? Is a 19th century historical piece. And then also the one that's entitled Indians and Invaders, Citizenship Clause and Illegal Aliens focuses on Section 1 of the amendment, on the Citizenship Clause of Section 1. And the paper on the legal tender cases, a new approach to congressional power, revisiting the legal tender cases, is about Supreme Court decisions on the constitutionality of paper money that were rendered in the 1860s and up until the 1880s. Constitutional false positives and the populist moment was about constitutional development in the late 19th century, basically focusing on the 1890s. Cherokee removal in the 14th Amendment was talking about the Trail of Tears and then how that had an influence on some of the thinking behind Section 1 of the 14th Amendment.
If we go to the next page of your CV, you have a list of recent professional activities. Do any of those relate to the history of the 14th Amendment?
Yes. So the podcast on Section 4, which I haven't written a whole article about that, but I did write about that in a piece of one article. I did a podcast with Eric Foner, who is basically America's leading historian on Reconstruction, earlier this year. And then the symposium piece is the one I mentioned earlier. That's my draft paper about another aspect of Section 3. And then there was a presentation about the Section 3 article last fall, and then I gave a talk last year about my biography of Bushrod Washington at John Marshall's house, which was rather fun.
And on the last page, I'm not going to highlight all of these, but did some of these also relate to Section 3 of the 14th Amendment?
Yes, I did a podcast with Professor Dan Hemmel in January of 2021 about Section 3. That was, of course, in the immediate aftermath of January 6th, 2021.
And what about this entry about John Bingham with Kurt Lash?
Yeah, so that was a podcast I did with Professor Lash for the National Constitution Center about John Bingham's career. That was part of a series of events that commemorated the 150th anniversary of the ratification of the 14th Amendment in 2018.
When you're doing your historical scholarship on the 14th Amendment, what kinds of sources do you consider?
Well, I mean, I'm trying to look at primary sources because that's the best way to try to get at the truth of what happened. So I'm always most interested in looking at those.
What are the types of primary sources that you would look at in your scholarship?
Well, they kind of run the gamut, but you could look at congressional debates and reports, you can look at presidential documents, you can look at judicial cases, you can look at contemporary newspapers, contemporary books, basically any kind of source that would be a sort of first-hand account of what occurred in a particular time period.
I'm pulling up Petitioner's Exhibit 144. What is this exhibit?
This is an index of the materials that I considered for my expert report.
And if we walk through this index, we see some cases, there's some citations to law review articles, some statutes, citations to congressional record, etc. Are those the sorts of materials that you would review in your historical scholarship outside the courtroom?
Yes, they are.
Tell us a bit about the historical methodology that you used in forming your opinions in this case.
Well, I mean, the first thing you want to do is make sure that the sources you're looking at are true and accurate. I mean, usually that's pretty straightforward because they are official government records of one sort or another. For example, there was an official compilation of presidential documents assembled at the end of the 19th century, and I have a set in my office that I found in an antique shop one time, and so I refer to that just to make sure that if I see a document online that I can look it up to make sure it's a real document and there's not some error in transcription or something. For newspapers, it's a little more challenging. I mean, there are some sort of trustworthy databases of old newspapers, ones run by the Library of Congress. You can also cross-check newspapers because typically an article would be reprinted more than once, or at least the sort of substance of the article would be reprinted in another newspaper. So you can try to make sure that whatever you're looking at is, in fact, an accurate rendition of whatever the article is discussing.
As a historian, what do you do if there's some kind of ambiguity or mismatch among different historical sources?
Well, look, the first thing you're looking at is kind of what is the context of the source. Now, for example, in the case of the 14th Amendment, you would be more interested in what supporters of the amendment had to say than you would be about what an opponent of the amendment would have said. In the same way that if you were looking at a judicial opinion, you'd be more interested in what the court said rather than what any dissenting opinions said to understand what the opinion was about. Also, you would look at who the speaker or author was. Now, some people were just more authoritative than others in their exposition of the 14th Amendment. And at the top of the list, or near the top, would be John Bingham. I mean, not just because I wrote a book about him, but because he was centrally involved in all elements of the 14th Amendment's proposal and ratification and implementation. And this has been recognized by the Supreme Court many times and by scholars many times.
Can you tell us whether or not the historical methodology that you've just laid out was the method that you used in forming and presenting your opinions in this case?
It was.
At this time, petitioners move to admit Professor Magliocca as an expert in the history of Section 3 of the 14th Amendment.
Your Honor, we have no objection to Professor Magliocca's expertise. Obviously, we renew and endorse the 702 motion, Your Honor.
Professor Magliocca will be admitted as an expert in the history of Section 3 and 14 of the 14th Amendment.
Thank you, Your Honor. Let's start by setting the stage for the adoption of Section 3. What does the historical record tell us about why Section 3 was put into the 14th Amendment in the first place?
Well, the main thing that prompted Section 3 was that they wanted to keep officials who had left to join the Confederacy from returning to office unless they showed that they deserved a second chance to return to office. So basically, there were elections held throughout the South in 1865 after the war ended, and many of the same people who had been in office before the war and had left to join the Confederacy were returned to office, and some of them showed up to the new Congress and essentially said, okay, we're here to take our seats now, as if nothing had happened. And congressional Republicans were very upset at this idea. They felt that this was wrong. And so there was a proposal by the Joint Committee on Reconstruction to do something to exclude people like that from positions of authority unless they demonstrated some repentance or, deserved forgiveness.
Does the historical record tell us anything about whether that was intended as punishment for insurrectionists?
Yes, I mean, it was not intended as punishment. There was a number of senators discussed the fact that this was simply adding another qualification to office because of the events that had occurred.
What does the historical record tell us about the role that the oath plays in Section 3?
So the oath plays a central role, not just in the text, but in the rationale for Section 3, in two respects. I mean, the first is it was a way of limiting the scope of the provision. They didn't want to disqualify all former Confederates from office or from serving. They wanted to focus that on the people they thought were most responsible for secession and the Civil War. And the oath was a way to do that. Now, secondly, senators said, if you had sworn an oath to support the Constitution and you had broken it by engaging in insurrection and joining the Confederacy, it was a kind of moral perjury, that was a term that some people used, that you had engaged in, and you were just untrustworthy to hold office again unless you demonstrated some reason why you should be allowed a second chance.
What, if anything, does the historical record tell us about whether Section 3 was limited to the events of the Civil War or not?
It was not limited to the events of the Civil War, and we know that because first, the language was general. It just referred to insurrection or rebellion. And secondly, there were senators in the debate that made pointedly clear that they thought it also should apply to any future insurrection that might occur.
When did the 14th Amendment get ratified?
1868.
In the years after its ratification, walk us through some of the ways that Section 3 got enforced to exclude from office those who had been engaged in insurrection or rebellion in violation of their oath.
Okay, so this happened in different forms. In some states that were under martial law, the Union Army did the enforcing. In southern states that were no longer under martial law, state officials and state courts did the enforcing. Individual houses of Congress also sometimes did the enforcing if someone was a member-elect and then there was a question raised about whether they could be seated because of some involvement with the Confederacy. And then the individual House of Congress, the House or the Senate, would have to decide if the person could be seated or not. And then finally, in 1870, Congress created a federal civil action to enforce Section 3 by allowing U.S. attorneys to bring a writ of quo warranto to oust officials who were in office illegally because of Section 3.
You mentioned state courts enforcing Section 3. Tell us a little bit more about that history.
Yes, so in 1869, there were cases in North Carolina and Louisiana that addressed enforcement of Section 3 of the 14th Amendment against state officials pursuant to state enforcement mechanisms. So in North Carolina, there were two officials who were removed from office as ineligible, and in Louisiana, they didn't remove the person because of a procedural reason, but they said that it could have been had the procedural posture been correct.
Were those cases in North Carolina and Louisiana before or after the enactment of federal implementing legislation in 1870?
They were before. They were in 1869.
Tell us a bit about the history of amnesty under Section 3 and Congress's power to remove the disability by a two-thirds vote.
Right. So as soon as the 14th Amendment was ratified, applications poured in from people who were disqualified seeking a waiver. Basically, you would apply to your member of Congress, and then what Congress did initially was pass a series of measures that would simply give amnesty to people by name, right? There would be a list of names, all of these people get amnesty if you could get a two-thirds vote of each house to pass the legislation. After a couple of years, Congress decided to create a more general amnesty that did not involve individual names, and that was enacted in 1872 and gave amnesty to nearly all of the people covered by Section 3, except for a few hundred who were sort of considered the worst of the worst, including Jefferson Davis, the former president of the Confederacy.
And what does that history of amnesty tell you about the historical understanding of whether congressional legislation was needed to enforce the disability of Section 3?
Well, it tells me that people didn't think it was needed. Now, that goes along two dimensions. First, the people who were applying for amnesty must have thought that they needed it right away. And why did they think that? Probably because the amendment had been ratified and states were in a position to enforce the amendment if needed. Secondly, Congress granted amnesty to these individuals in some cases before any enforcement legislation was enacted. And in a sense, they were removing a disability that existed because the 14th Amendment had been ratified. They couldn't remove something that didn't exist.
I'm going to pull up the language of Section 3, and I want to first highlight the phrase insurrection. Have you studied the historical meaning that the word insurrection would have had at the time of ratification of the 14th Amendment?
Yes, I have.
What did insurrection mean at that time?
Well, according to the historical sources, an insurrection was any public use of force or threat of force by a group of people to hinder or prevent the execution of the law.
What were some of the historical sources that you looked at that informed your understanding of insurrection as a public use of force or threat of force to prevent execution of the law?
Well, I looked at historical examples of insurrections that occurred before the Civil War, as informed by some presidential documents about them. I looked at dictionaries, I looked at judicial decisions, and I looked at an authoritative treatment of the law of war that was issued during the Civil War.
You mentioned historical examples. Tell us a little bit more about what historical examples informed the understanding of insurrection during Reconstruction.
Sure. Well, there were two notable insurrections early on in American history. One was the Whiskey Insurrection, which is also known as the Whiskey Rebellion, and that happened in 1794 in Pennsylvania. It was a tax protest by farmers who were angry at a new federal tax on distilleries that had been put in as part of Alexander Hamilton's financial scheme for the federal government. And during that time, armed farmers basically attacked federal tax collectors who tried to collect the tax, or used intimidation to prevent them from doing so. Eventually, President Washington called out the militia to sort of restore the legal authority of the government on tax collection, and a few people were prosecuted, but President Washington pardoned them all.
How many roughly armed farmers were involved in the Whiskey Insurrection?
In the hundreds.
You mentioned that there was another example you looked at. Tell us about that.
Yes, the second example was called Fry's Insurrection. That was in 1799. That was in a different part of Pennsylvania. It was a different group of farmers who were upset about a different tax. This time it was a federal property tax. And they used intimidation to prevent the tax assessors from the federal government to come in and do the property assessments that would have been necessary to collect the tax.
And what was the scale of the violence involved in Fry's insurrection?
Well, there was no actual violence. There's no record of anybody being killed. And again, we were talking about kind of hundreds of armed farmers who were sort of behind the sort of resistance to this tax.
If there was no actual violence, in what sense was it understood to be an insurrection?
Well, it involved a threat of violence. That is, there was violent intimidation of the federal tax officials. And that did the trick, at least from the point of view of the farmers, for some period of time.
What relevance did the Whiskey Insurrection and Fry's Insurrection have to the historical understanding of the meaning of insurrection during Reconstruction?
Well, these were well-known examples. I mean, probably the Whiskey Insurrection was a little better known. because it was referred to in the 39th Congress. I mean, you can find books written about the whiskey insurrection in the run-up to the Civil War, and also one of the leading cases on sort of discussing insurrection arose out of Fry's insurrection. It was a case from 1800, so all of this would have been background that people would have been familiar with at the time.
These weren't obscure examples?
No, not at all.
I'm sorry, Professor, so when you say that it informs when an insurrection was at a time, is that because like case law called them insurrections, or?
Well, yes, in part. The case of Fry's, for example, which arose out of Fry's insurrection, described it that way, as did President Adams' pardons of the individuals who were involved.
Okay.
Hmm?
And you've already touched on this, but did either of these examples rise to the level of a full-scale war or rebellion?
No.
You also mentioned that you looked at some dictionary definitions. Tell us what we're looking at here.
This is Webster's Dictionary from 1828.
This is on page 785 of your appendix. How did Webster's dictionary define insurrection at that time?
Webster's defined it as a rising against civil or political authority, the open and active opposition of a number of persons to the execution of law in a city or state.
And did Webster say anything about any difference between insurrection on the one hand and rebellion on the other?
Yes, it said that a rebellion was basically an attempt to overthrow the government or create a new government. I mean, people to some degree use those terms interchangeably because, as I said, the whiskey insurrection is sometimes called the whiskey rebellion, but this definition defined them more starkly, or differentiated them more starkly.
Was this the only example of a dictionary definition that you found informative?
No.
I want to pull up page 747 of your appendix. What is this?
This is a dictionary from 1848 by the Reverend John Bogue, who was a noted English lexicographer.
And why did you look there?
Well, because it is he was a noted person. I mean, not as famous as Noah Webster, obviously, but it had a definition of insurrection within it.
How did the definition in this dictionary compare to what we just looked at in Webster's dictionary?
It is essentially identical.
You also mentioned that you looked at cases defining insurrection. Tell us first a bit about how those cases came up.
Right. So prior to 1862, there was no crime of insurrection. So the only time that cases discussed insurrection came in treason cases when judges were instructing juries, giving them a charge on treason, and invariably they would discuss what an insurrection was in those charges.
If we go to page 750 of your appendix, is this one such charge?
Yes.
And tell us the circumstances of this charge.
Okay, so this is a charge to a grand jury in the United States Circuit Court in Missouri in 1861. The way things worked then, Supreme Court justices would participate in trials to some extent, and so this grand jury charge was presided over by John Catron, who was an Associate Justice of the court at that time.
If we go to page 752, I apologize, sometimes these historical sources are a little bit hard to read, but can you tell us how Justice Catron defined insurrection?
Yes, he said that conspiracy and the insurrection connected with it must be to affect something of a public nature concerning the United States. And that included overthrowing the government or to nullify and totally hinder the execution of some U.S. law or the U.S. Constitution or some part thereof, or to compel its abrogation, repeal, modification, or change by a resort to violence.
And how does that inform your opinion here?
Well, I mean, that is an authoritative statement of law in 1861, close to the time when the 14th Amendment was ratified. And it is consistent with the dictionary definitions just seen in saying that an overthrow of the government was not required to have an insurrection. And it's consistent with the examples of the whiskey insurrection and Fry's insurrection, where there was no attempt to overthrow the government. There was an attempt instead to resist the execution of law.
Was this instruction by Justice Catron an isolated example in the case law?
No.
Tell us a bit more about that.
Well, there are other treason cases from before the Civil War that have very similar language. So one I mentioned earlier was a case they called Case of Fries, which was about Fries' insurrection, and then another called United States versus Hanway from the 1850s.
How did the charges in Case of Fries and Hanway compare to Justice Catron's charge here?
They're essentially identical.
You said you also looked at sources related to the laws of war. I want to pull up page 553 of your appendix. Tell us what we're looking at here.
So this is the legal code that was issued to the Union Army during the Civil War.
And why did you look at this source by Francis Lieber?
Yes, well, a couple of reasons. First is it was the authoritative sort of law of war that applied during the Civil War. And secondly, Francis Lieber was probably the leading legal scholar of his day, and so he's a particularly authoritative author or speaker on these kinds of questions.
On page 594 of your appendix, walk us through what Francis Lieber said constituted an insurrection.
He said that insurrection is the rising of people in arms against their government or a portion of it or against one or more of its laws.
And how, if at all, in this source, did insurrection contrast to civil war or rebellion?
Well, Lieber described a rebellion as simply a very large insurrection, although he then went on to say that often it involved an attempt to overthrow the government or to set up a separate government.
And again, how does this discussion by Francis Lieber inform your opinion as to the understanding of insurrection during Reconstruction?
Well, it's consistent with all of the other sources that I looked at.
Can you tell us whether or not you saw any serious disagreement during Reconstruction about the meaning of the phrase insurrection?
No, I did not.
How have today's historical scholars addressed the definition of insurrection?
Well, of the ones who have addressed it recently, they have been in agreement basically with the opinion that I'm offering and these sources that you've seen. In particular, the draft paper by Professor William Bode and Professor Michael Stokes-Paulsen, and the work, again, in a draft paper by Professor Mark Graber at the University of Maryland.
If we go back to the language of Section 3, I want to now turn our attention to the phrase insurrection or rebellion against the same. How, if at all, does the language against the same affect your opinion as to the historical understanding of Section 3?
Well, that the language limits the definition of an insurrection for Section 3 purposes to one that is against the Constitution of the United States.
And so how does that limit or change the definition of insurrection?
Well, it eliminates a certain class of insurrections from things that would be considered for purposes of Section 3. So the most obvious example would be an insurrection against state or local law. That would not be a Section 3 insurrection because it does not involve the Constitution of the United States.
Does the historical record tell us anything about why Section 3 would be limited to a particular type of insurrections, namely those against the Constitution?
Okay, well, one is, again, they were concerned to limit the scope of the provision, right, and this is a way of doing that. And then second, there's a thought that since the oath was central to both sort of the limitation and the rationale, the oath that you take is to the Constitution of the United States. It's not to the United States generally. And so it makes sense to think that the insurrection we're concerned about, or rebellion, would be one against the Constitution that you swore an oath to support.
I want to draw our attention now to the language, shall have engaged in insurrection or rebellion. Does the historical evidence shed light on what it means to have engaged in insurrection, or how that would have been understood historically?
Yes, I mean, during Reconstruction, engage in insurrection was understood broadly to include any voluntary act in furtherance of an insurrection against the Constitution, including words of incitement.
What sorts of historical sources did you look at in forming that opinion?
Well, I looked at judicial decisions. I looked at opinions of the United States Attorney General. Those were sort of the two leading sources that I looked at.
I want to pull up page 788 of your appendix. Tell us what we're looking at here.
This is an opinion by the United States Attorney General in 1867 interpreting the Military Reconstruction Acts of Congress.
Okay, and what's the historical significance of this opinion of the U.S. Attorney General interpreting the Reconstruction Acts?
Okay, this will take a minute to explain. So in 1867, Congress passed a series of measures that placed most of the former Confederacy under martial law. And in doing so, Congress ordered that these states hold new elections for conventions that would write new state constitutions and would ratify the 14th Amendment. Now, as part of the direction as to how these elections were to be run, Congress said that people who would be disqualified from office by the language of Section 3 of the 14th Amendment should not be allowed to vote in the elections for these new conventions. And the Union Army was tasked with enforcing this provision.
So just to back us up a little bit, this is May of 1867. Was that after Congress had submitted the 14th Amendment for ratification?
Yes, it was in the period between the submission of the amendment to the states and its ratification. So the statute refers to the proposed Section 3 of the 14th Amendment.
And to be clear, how did the language of the Reconstruction Acts compare to the language of the proposed constitutional amendment in Section 3?
It was identical.
Did this opinion of the U.S. Attorney General have any kind of legal effect?
Yes, it did. The opinion was approved by the Cabinet. We have the Cabinet minutes on that. And then was the basis for instructions that were issued to the Union Army commanders in the former Confederacy as to how they were to implement Congress's directive on these elections.
What form did the instructions to the Union Army take in terms of implementing the opinion of the Attorney General on the Reconstruction Acts?
Basically, they were instructions issued by the Secretary of War. Also, Ulysses S. Grant was involved because he was the general of the armies at the time.
Can you tell us whether or not those instructions included the language of this opinion?
They did.
So how would you characterize the historical significance of these opinions by Andrew Johnson's Attorney General?
Well, they are an authoritative interpretation by the Attorney General of the United States on the language that ended up being ratified in Section 3 of the 14th Amendment.
Who was the Attorney General at that time?
Stanbury.
I want to direct our attention to page 800 of your appendix. Walk us through what Attorney General Stanbury said about what it means to have engaged in insurrection.
Well, he described it as some direct, overt act done with the intent to further the rebellion. And then later he said that the act had to be voluntary because there was some concern about people who were drafted into the Confederacy that they not come under the disqualification because they had not acted voluntarily. So basically, a direct, overt act done with intent to further the rebellion that was voluntary.
There's a discussion here of mere acts of common humanity and charity can't be considered as participating in the rebellion, or forced contributions can't be seen as participation, correct?
Correct.
Did the opinion of the Attorney General identify any other conduct in furtherance of insurrection or rebellion that would be considered outside the scope of Section 3?
No.
What does this source tell you about whether or not someone would have needed to have taken up arms in order to have been understood to have engaged in insurrection at this time?
It was not required.
Let's go to page 804 of your appendix. Tell us what we're looking at here.
Well, this is a second opinion that the Attorney General issued because, remember, the Army had never organized an election before, so the Union Army commanders requested additional guidance from the Attorney General as to how to do this. So a second opinion was issued.
Does this second opinion have any historical significance?
Yes, again, it was approved and used as a basis for instructions to the Union Army commanders.
If we go to page 815, walk us through what this second opinion of the Attorney General tells us about what it meant to have engaged in insurrection.
Well, again, here it says that it must be an overt and voluntary act done with the intent of aiding or furthering the common unlawful purpose, namely the insurrection. And then that voluntary contributions, even such indirect contributions as arise from a loan of money or the purchase of bonds, would count for disqualification.
And so again, what does that tell us about whether or not Section 3 was understood to apply only to those who took up arms against the Union?
It did not apply only to those who took up arms.
Later in that page, what did Attorney General Stanberry say about speech?
Well, he said that disloyal sentiments, opinions, or sympathies would not disqualify, but when a person has, by speech or by writing, incited others to engage in rebellion, he must come under the disqualification.
Now, we've seen this discussion in the Attorney General's opinion about a voluntary act in furtherance of the rebellion. Tell us how early judicial cases compared to this discussion in the Attorney General's opinion.
They are consistent.
If we go to page 203 of your appendix, what is this case?
This is Worthy versus Barrett, one of the North Carolina cases that I referred to earlier,
And when was this case decided?
1869.
On the second page, what does the Worthy Court say about what constitutes engaging in rebellion?
Well, a voluntary act by personal service or by contributions other than charitable of anything that was useful or necessary.
How did that compare to what we just looked at from Attorney General Stanberry?
It's essentially the same.
Were there any other cases addressing this language at this time?
Yes, there was a federal case in North Carolina in 1871, United States versus Powell, that again said that a voluntary act in furtherance of insurrection or rebellion was the definition of engaged in insurrection.
Were there any cases at this time that disagreed with Attorney General Stanberry's opinion that words of incitement were enough to have engaged in insurrection?
Not that I'm aware of, no.
In your report, you also discuss some pre-Civil War cases on the law of treason. Why did you look at those cases?
Well, as I mentioned earlier, the only time that judges discussed insurrection before the Civil War came in treason cases, so naturally I wanted to look at those.
Do those cases, those treason cases from before the Civil War, shed any light on this question of whether or not someone needed to have personally taken up arms in order to have levied war against the government or engaged in insurrection?
Yes, they made clear that you do not need to take up arms to be engaged in levying war. You could do so by encouraging or instigating an insurrection.
And did those cases specifically address this issue of instigation or incitement?
Yes, they do.
And you touched on this a minute ago, but walk us through kind of what those cases said about incitement.
Well, I mean, basically they said that just because you had not been on the scene of the violent event, or that you had sort of not taken up arms, that didn't matter. That what mattered was basically you could be engaged in an overt act supporting treason if you instigated, incited, encouraged that activity.
During Reconstruction and during the Civil War, did Congress ever address this issue of disqualifying insurrectionists?
Yes. So as I mentioned earlier, if a member-elect showed up to the House of Representatives or the Senate, there could be a challenge about whether that person was involved in the Confederacy, and then each House of Congress would have to assess whether their involvement disqualified them.
Let's turn to page 463 of your appendix. What is this historical source?
This is Hines Precedents of the House of Representatives, which is an authoritative source of decisions by individual houses of Congress running through the 18th and 19th centuries.
Why did you look at Hines precedents?
Well, this is where you would look for precedents from individual houses of Congress as opposed to, say, legislation or judicial precedents.
Tell us a bit about the case of John Young Brown.
Yes, so John Young Brown was a member-elect to the House of Representatives from Kentucky, and when he arrived in 1868, he was challenged on the ground that he had given aid to the Confederacy.
Let's look at page 465 of your appendix. And I want to pull up some language here. What are we looking at here?
This is essentially a letter to the editor that Mr. Brown wrote early during the Civil War, in which he advocated violence against Union troops that might enter Kentucky.
And was there any argument in the case of John Young Brown that he had done anything to aid the rebellion other than this letter to the editor?
No, this was all that he was accused of doing.
How did Congress decide the case of John Young Brown?
They did not seat Mr. Brown.
On what basis?
That he had been involved with the Confederacy and was disqualified.
Now, you said this case was in 1867, correct?
Yes, 1868.
1868? Was that before or after Section 3 had been ratified?
It was a little bit before Section 3 was ratified, so it was not a Section 3 enforcement, strictly speaking.
So on what basis did Congress say that Mr. Brown was disqualified?
Well, the House has broad power to disqualify or refuse to seat members elect, especially in that era. And so basically they said that he had given aid to the Confederacy through this editorial.
If the case of Mr. Brown was not a case applying Section 3 itself, why did you look at it in informing your understanding as to the scope of Section 3?
Well, because this decision was taken in the year that the 14th Amendment was ratified, and it concerned the kind of conduct that would be considered disqualifying. So it seemed like informative as an example for what people might have been thinking about when the provision was subject to ratification.
Did you look at any other congressional cases of disqualification or exclusion?
Yes, there was one other case in 1867 of Philip Thomas. Mr. Thomas was a senator-elect from Maryland, and he had given $100 to his son before his son went off to join the Confederate Army, and he was challenged on the grounds that he had given aid to the Confederacy by doing that.
Had he done anything other than give $100 to his son when his son was leaving to join the Confederate Army?
No.
How did Congress address the case of Philip Thomas?
They did not seat Mr. Thomas.
On what basis?
That he had given aid to the Confederacy. That was disqualifying.
Same question as with Mr. Brown. Was that a Section 3 case?
No, it was not, because it came in 1867, a year before the 14th Amendment was ratified.
And did you still consider that to be relevant in understanding the historical backdrop to Section 3?
Yes, for the reasons I just identified, that it happened while Section 3 was pending before the states and concerned what kind of conduct would be considered disqualifying from office.
You've mentioned historical sources discussing a voluntary act in support of insurrection by words or deeds. Did the issue of inaction ever come up? Were there any cases where an individual was charged for having abdicated a duty to protect the Constitution?
No.
So does the historical evidence kind of tell us anything one way or another about whether they saw any kinds of inaction as potentially being covered by Section 3?
No.
If we step back and look at all the historical sources that you've just discussed, what do those sources tell us about whether or not an individual is disqualified or was understood to be such at the time without having taken up arms against the government himself or herself?
Well, the answer is you could be disqualified without having taken up arms against the government in the period of the Civil War.
I want to move now to a discussion of offices and officers. Set the table for us a little bit about how those terms come up in Section 3.
Sure. Well, Section 3 says that no person shall hold any office, civil or military, under the United States or under any state if they had taken an oath as an officer of the United States, among other things, to support the Constitution of the United States and then have engaged in insurrection against the same.
So to be clear, first you have to have taken an oath as a qualifying official or officer of the United States and then engaged in insurrection?
Correct.
And if you've done that, if you've taken an oath as an officer and engaged in insurrection, then what kinds of offices or positions are you disqualified from at that point?
Right. Right. So the first portion describes the offices and the second portion describes the officers.
Have you looked at historical evidence bearing on the question of whether the office of the presidency was understood to be an office under the United States such that a disqualified individual could not take that office?
I have.
And what is your opinion on that question?
My opinion is that during Reconstruction, the presidency was considered an office under the United States for purposes of Section 3.
And have you looked at historical evidence addressing whether or not the president during Reconstruction was considered as an officer of the United States?
I have.
And what is that opinion?
My opinion is that during Reconstruction, the president was considered an officer of the United States for purposes of Section 3.
In addressing the meaning of officer and office, what kinds of historical evidence did you look at?
So I looked at congressional debates and reports. I looked at presidential documents. I looked at opinions of the United States Attorney General. I looked at judicial decisions. Contemporary newspapers were the main ones.
Did historical sources at this time define, in the context of Section 3, what it meant to be an officer of the United States?
Yes, they did.
And what did they say you had to do in order to be an officer of the United States?
Well, the main thing was that you had to have taken an oath to support the Constitution. That, again, the oath was central to the text and the purpose, and it was also considered pivotal to the question of whether you were an officer or not.
If we go back to the North Carolina Supreme Court's decision in Worthy, was this one of the cases on this issue that you were mentioning earlier?
Yes.
What did the Worthy Court's decision tell us about who is an officer?
Well, the court said that it did not know how better to draw the distinction between an officer and a mere placeman, let's say an employee, than by making his oath the test. And then went on to say that every officer is required not only to take an oath of office, but an oath to support the Constitution of the state and of the United States.
Did Attorney General Stanberry ever address this issue as well?
Yes, he did in one of his opinions that we looked at earlier.
If we go back to the first opinion of the Attorney General on page 797 of your appendix, walk us through what Stanberry said about officer of the United States under the language of Section 3.
Well, he said that the term was to be used in its most general sense and without any qualification, and that the oath was central to determining whether someone was an officer or not.
And how did Attorney General Stanberry's opinion that officer is used without any qualification relate to your opinion as to whether the presidency was understood to be covered at this time?
Well, there was no qualification for the President of the United States.
I want to ask you briefly about an argument that's been made in this case, that the President's oath under Article 2 to preserve, protect, and defend the Constitution of the United States is not, for purposes of Section 3, an oath to support the Constitution of the United States. Are you familiar with that line of argument?
Yes, I am.
Have you seen any historical evidence that bears on the question of whether the President's oath to defend the Constitution would have been understood to fall under Section 3?
I have.
I'm pulling up page 869 of your appendix, and I apologize, this is another one of those hard-to-read historical sources, but what are we looking at here?
This is a grand jury charge that was issued by a federal circuit judge in Tennessee in 1870, and it was reprinted in a newspaper.
Well, why are we looking at a newspaper here?
Well, because in those days, grand jury charges were often reprinted in newspapers as a kind of exercise in public education, as well as just to tell people what was going on in the courts.
And who originally identified this historical source?
I did.
Okay. What did this charge tell us about oaths in Section 3?
Well, Judge Emmons said, the oath which shall have been taken need not be in the precise words of the amendment, quote, to support the Constitution of the United States. He went on to say that there were slight differences in the forms of the oaths that people took, but the important thing was whether they include, substantially, even if not literally, an obligation to the federal power, and that the jury was not to consider the argument that, in effect, the wording of the oath did not include the word support.
How does that relate to your opinion that the oath that the president swears to defend the Constitution is covered by Section 3?
It leads me to the conclusion that it is covered because the difference in wording is irrelevant.
Did you also consider any presidential proclamations in addressing whether the president was considered to be an officer of the United States at this time?
I did.
And tell us a bit about those proclamations.
Well, these are proclamations that were issued by President Andrew Johnson, who was the president at the time that the 14th Amendment was ratified, in which he explained how he had the authority to create provisional governments in the Confederacy following Lee's surrender to Grant.
If we look at page 442 of your appendix, is this one of those proclamations?
Yes, it is.
Tell us a bit about the context here.
Yes, well, the president is issuing, in effect, an executive order. They called it a proclamation then, usually, where he's establishing a government in one of the former Confederate states, and he justifies that on the grounds, in part, that he is the chief civil executive officer of the United States.
And remind us what year this was.
This is 1865.
Shortly before Section 3 of the 14th Amendment was adopted?
Yes.
Was this an isolated example of President Andrew Johnson?
No, he issued the same proclamation for different states throughout the Confederacy, and these proclamations were widely reprinted in newspapers at the time because they were setting forth the terms of the governments that were to govern in several states of the United States.
Was Andrew Johnson the only president in the 19th century to refer to himself as an officer of the United States?
No. President John Tyler in the 1840s referred to himself as the chief executive officer, and President James Buchanan, who was Lincoln's predecessor, referred to himself as the chief executive officer under the Constitution.
In your report, you also talk about examples of how this issue came up in Congress. Tell us a bit about that.
Yes, well, there were references to the president as either the executive officer of the United States or an executive officer of the United States in Congress multiple times during the Congress, either that proposed the 14th Amendment or the one that oversaw its ratification.
I want to look at page 488 of your appendix, an excerpt from the Congressional Globe. What are we looking at here?
This is a speech by John Bingham in 1868 in which he describes the president as the executive officer of the United States.
And remind us what John Bingham's role was in the adoption of the 14th Amendment.
Well, he was the principal drafter of Section 1 of the amendment, and he was a member of the Joint Committee on Reconstruction, which was sort of the pivotal committee that essentially assembled the proposal of the 14th Amendment more generally.
Tell us about some of the other contexts in which this issue of the president as an officer of the United States came up at this time.
Yes, well, it was also addressed in President Johnson's impeachment trial, which occurred in 1868, shortly after this speech that Bingham gave, in which the president's own lawyer described him as an executive officer of the United States.
Was that an isolated reference in Congress at the time?
No, there were many other references to the president as different formulations, whether executive officer of the United States, the executive officer of the United States, in one case, mere executive officer of the United States, by various members of Congress, including Bingham on at least one other occasion.
Let's look at page 811 of your appendix. This is from the second opinion of Stanberry on the Reconstruction Act. And what did he say on that issue?
Well, he said that the president, who was his boss, is simply an executive officer.
Did anyone at the time specifically address the question of whether Section 3 covered the office of the president?
Yes.
How did that come up?
That came up during the Senate debate on the Section 3 language.
I'm pulling up page 477 of your appendix, excerpts from the Congressional Globe from that time. Walk us through how that issue came up in the debate about Section 3.
So a question was posed as to why the president or the vice president was not specifically mentioned among the offices listed in Section 3. And Senator Lott Morrill of Maine, who was a supporter of the 14th Amendment, said, well, let me call the senator's attention to the words, hold any office, civil or military, under the United States. And then the response to that was, in effect, oh, yes, I'm sorry about that, never mind. When I first saw this excerpt in 2020, when I was researching the original article, it was very exciting because you rarely get such a clear statement of legislative history, right? Normally legislative history is about things that you're not particularly interested in, or they're more vague in their phrasing. This is about as specific as you can get.
Were you the one who dug this up?
Yes.
Did anyone come back later in the debate and say, actually, you were wrong, we are excluding the presidency from Section 3?
No.
Talk to us a bit about how Jefferson Davis came up in the debates around Section 3.
Well, there was a consensus at the time that Jefferson Davis was ineligible to be president because of Section 3. And when Congress considered granting amnesty to individuals, an objection to granting amnesty to everyone was that, well, that would give Jefferson Davis amnesty, and that meant that he could then be president of the United States, which people thought was just unacceptable.
And when specifically did that issue of kind of amnesty, including Jefferson Davis, come up in these debates?
Well, it came up more, it was discussed a little bit during the time that the 14th Amendment was under ratification pending, but it really came up more when the debate on amnesty heated up in the 1870s, around the time of the General Amnesty Act in 1872, and then again in a debate in 1876 when they were thinking about giving amnesty to the remaining few hundreds of people who had not been given amnesty in 1872.
In the discussions about amnesty that might allow Jefferson Davis to become the president again, describe kind of the tone of the supporters of Section 3 at that prospect.
Well, they thought it was kind of preposterous that Jefferson Davis could be eligible to be president of the United States, and they insisted that the only way that could happen is if he were given amnesty.
Can you tell us whether the historical purpose that you've identified behind Section 3 tells us anything about whether or not the president was understood to be excluded?
Well, yes, in the sense that it would have been odd to say that people who had broken their oath to the Constitution by engaging in insurrection were ineligible to every office in the land except the highest one.
Did the debates ever talk about kind of high office versus sort of lower level officials in the context of Section 3?
Yes, there were references in the Senate to the fact that in part the idea of Section 3 was to go after people who were the most responsible for secession and the Civil War, and that tended to include higher level officials. They were seen as basically more blameworthy for what had happened than, say, a lower level official.
I want to ask you just a few final questions. Last Friday, Trump served an expert report in this case by Robert Delahunty. Have you had a chance to review that expert report?
I have.
Describe for us your level of familiarity with the people who today are recognized as experts on Section 3.
I'm very familiar with them.
When was the first time you had ever heard of Robert Delahunty?
When I learned that he would be an expert witness in this case.
How would you characterize Robert Delahunty's contributions, if any, to the scholarly debate on the history of Section 3?
I don't know of any.
Is Robert Delahunty someone that you would consider to be an expert in this history?
No.
Robert Delahunty cites an article, a law review article.
Your Honor, I'm going to object to this entire line of questioning. This was not part of his expert report. It's wholly improper.
Your Honor, we got his expert report at midnight on Friday, and I understood that we were able to do short rebuttal or response to that since we did not have a chance to respond in writing.
Your Honor, he may contend with Professor Delahunty's arguments if he sees fit, but he is not an expert on Professor Delahunty's expertise. He is not here to render an opinion on whether he's a better expert than Professor Delahunty is a better, or Professor Delahunty is a better expert. So I understand some experts think they're, well, I won't say anymore. Thank you, Your Honor.
The court will sustain an objection to the extent that I agree. I don't think it's proper for one witness to comment on the other witness's expertise. That's what you do in cross-examination. However, I will allow the professor to talk about his response to the opinions of Professor Delahunty. Is that the correct name?
Yes, ma'am.
Thank you, Your Honor. One of the sources that Professor Delahunty relies on is an article by Professors Blackman and Tillman on the question of whether or not the presidency is an office under the United States. Is that an article that you're familiar with?
I am.
Can you situate that article in the broader scholarly debate surrounding the history of Section 3?
Well, I mean, of the draft papers that have considered the question of whether the president is an officer of the United States for purposes of Section 3, and there aren't that many, I would say that their position so far is in the minority.
Tell us who some of the other scholars are who have addressed this issue and disagreed with the Blackman and Tillman position.
Yes, so there's the draft paper by Professors Bode and Paulson that I mentioned earlier, the draft paper by Professor Graber that I referenced earlier. There's another draft paper by John Vlalopoulos, I believe is the correct pronunciation of his name, and they all take the view that the president is an officer of the United States for purposes of Section 3, as I do.
I want to ask you about a few other sources that are cited in Mr. Delahunty's expert report. I want to pull it up on the screen here, Petitioner's Exhibit 227. If we go to page 10, there's a discussion of the presidential election of 1872 and the candidacy of Horace Greeley, which I think was also referenced in opening statements. Have you reviewed this portion of Mr. Delahunty's report?
Yes, I have.
And tell us what you understand to be the argument about Horace Greeley in 1872.
Well, I understood the argument to be that Horace Greeley ran for president in 1872 as the Democratic nominee, and no one objected to that on the grounds that he was ineligible to do so under Section 3, and that therefore that might mean that Section 3 does not apply to the presidency.
Do you agree with that argument?
No.
Why not?
Horace Greeley was not a Confederate. He was a loyal supporter of President Lincoln during the war. He was a supporter of radical Republican policies during Reconstruction early on. He was a supporter of the conviction of Andrew Johnson in the impeachment trial in 1868. Section 3 had nothing to do with him.
Didn't anybody kind of criticize him for Southern sympathies, though?
Yes, but I mean, that was just sort of political rhetoric that people were putting out. And, you know, there's a distinction between that and the sort of legal ineligibility that would attach to Section 3. Now, for example, John Bingham gave a speech in 1872, a campaign speech against Greeley. He was campaigning for Grant's reelection, and he expressly distinguished Horace Greeley, whom he opposed, but basically he could be president if he won, from Jefferson Davis, who he said could not be president because of Section 3 of the 14th Amendment unless Davis got amnesty. So it was pretty clear. Davis was a Confederate. He was ineligible. Greeley was not a Confederate. He was eligible.
And I know you said that Horace Greeley was not a Confederate and so wasn't covered by Section 3, but let's assume for the sake of argument that he was otherwise covered by Section 3. What, if anything, does the state of amnesty by the time of the 1872 election tell us here?
Well, if Greeley had been covered by Section 3, he would have received amnesty under the General Amnesty Act that was enacted in the spring of 1872. So it wouldn't, Section 3 couldn't have applied to him anyway while he was running for president.
Does the example of Horace Greeley tell us anything here?
No.
There's also a discussion in Mr. Delahunty's report citing to an article by Professor Kurt Lash about earlier drafts of Section 3 of the 14th Amendment and whether those shed any light on whether the presidency is covered. Are you familiar with those arguments?
Yes.
And what is your opinion on those arguments from a historical standpoint?
Well, they're inconclusive, right? That is to say, you can't draw a conclusion from early drafts as to what the final draft means unless somebody says the reason we're changing the draft from this to that is because of something. So nobody made any such commentary about the differences between early drafts and the final draft. I mean, it would be nice if we had more information about the drafting and ratification of the 14th Amendment, but we have what we have. And so, therefore, you really can't draw any conclusion about the final draft from any of the earlier drafts.
Is there any indication that you've seen in any of the congressional debates about Section 3 that anyone intended to exclude the president or the presidency?
No.
I want to turn to page 30 of the report. There's a discussion here of 3 sources identified by Professors Blackman and Tillman that they cite to suggest the president is not constitutionally an officer of the United States. Did you review that portion of Mr. Delahunty's report?
I did.
Were those historical examples persuasive to you?
No.
Why not?
Well, a couple of reasons. I mean, first of all, they all arise a decade after the ratification of the 14th Amendment. They are not about Section 3. That's the second reason. Now, third is, I don't know who David McKnight was. But put another way, he's not Noah Webster or Francis Lieber, so he doesn't have the same sort of authority. So the statement in his treatise is of only very limited importance. The other 2 statements came out of the Senate impeachment trial of Secretary of War William Belknap. He was accused of corruption, among other things. And the thing is that, first of all, that was a trial that was not about the president. So the statements by the senators that the president was not an officer of the United States were a kind of dicta, basically, that had nothing to do with the trial that they were involved in. Now, let's contrast that with the statements about this issue in the impeachment trial of Andrew Johnson. Right? Now, that happened in 1868 when the 14th Amendment was ratified. That was about the president. He was on trial. People did say that he was an officer of the United States. His own lawyer said it, as well as members of the of Congress. And it was an actual issue in the trial. And the reason for that is that President Johnson was accused of committing a high crime and misdemeanor by refusing to follow an act of Congress because he thought it was unconstitutional. Okay, so set aside what you think of that argument. Part of making that argument meant saying, well, he wasn't a judicial officer, and only judicial officers can set aside laws because they are unconstitutional. He's only an executive officer. So that was part of the reason why people were describing him as an executive officer or the executive officer. So it was actually related to the issues under discussion in a way that, of course, these statements that you see here in the Secretary of War's trial some years later were not. So I just think overall it's not persuasive evidence on the question.
I want to briefly ask you about Professor Delahunty's argument that Section 3 is too ambiguous for courts to decide without congressional implementing legislation. Do you have a view on that issue from a historical standpoint?
Well, yes. First of all, we see examples of people applying Section 3 and interpreting it at the time, right? And so, in the end, it's really no different than a lot of other legal standards, which are broad, and you have to figure out how to apply them to a particular set of facts. But that's what we do with standards like that. Now, it would be nice if we had more examples, more cases to guide us. But I had a colleague, you know, she's no longer with us now, but when people would say, why don't we have more information before we make a decision, she'd just look at you and say, alas, you know, like that we have what we have. We have to work with what we have. But there's no reason to think that we can't work with what we have.
Do you agree with Mr. Delahunty's argument that the phrase insurrection was ambiguous at the time?
No, I mean, we've gone through quite a bit of material to define what insurrection was, and you know, that doesn't mean we know how it should be applied to every set of facts, but there's quite a bit of material that defined what an insurrection was as of Reconstruction.
Do you agree with Mr. Delahunty's argument that the phrase engaged in insurrection does not include speech?
No, I do not agree with that.
Mr. Delahunty cites the Second Confiscation Acts in making that argument. Can you explain to us what the Second Confiscation Acts were and kind of what you understand that argument to be?
Sure. The Second Confiscation Act was a criminal statute enacted in 1862 that defined insurrection by listing a series of terms, including to set afoot, to incite, and to engage. And then my understanding is the argument is, well, Section 3 did not include the word incite in its terminology in the way that the Second Confiscation Act did, so therefore maybe incite was not included by Section 3.
Do you agree with that argument from a historical perspective?
No.
Why not?
Well, first of all, I mean, there's a difference between a criminal statute, which is what the Second Confiscation Act was, and the provision of Section 3, which is creating a new qualification for office. So the comparison is not that close. Secondly, there's no explanation in the debates on Section 3 as to why the word incite was not included. So again, it's like you can't really draw conclusions from a prior version, right, as compared to the final version unless you know something about why there's a difference. Thirdly, constitutional provisions are not statutes. They are not as specific as statutes. They're written in general language. That was well understood at the time. Chief Justice Marshall explained this in his opinion for the court in McCulloch versus Maryland, that you can't make constitutions as specific as statutes because then they would be incredibly long, incredibly hard to understand for average people. So, you know, constitutional provisions like Section 3 were written in general terms.
What, if any, conclusion do you draw from the fact that Section 3 does not specifically mention incitement?
I don't draw any particular conclusion from it. I draw conclusions from the other sources that interpreted Section 3, mainly the Attorney General's opinions.
My last question for you is, if we step back and evaluate Professor Delahunty's historical methodology laid out in his report as a whole, what is your opinion as to the reliability of his historical method?
Your Honor, we will object again.
Sustained.
Professor Magliocca, you discussed earlier the types of historical methodologies that scholars in history typically follow when they are deciding historical questions, correct?
Yes.
And can you tell us whether or not, in your view, Mr. Delahunty followed those prescribed methodologies?
Your Honor, objection again. And further, we note that Mr. Magliocca has not been, I'm sorry, Professor Magliocca has not been proffered as an expert on historical methodologies.
Sustained. He can talk about his methodologies, but you can cross-examine Professor Delahunty on his.
Understood, Your Honor. We don't have any more questions. Thank you.
Cross-examination.
Good morning, Professor Magliocca.
Good morning.
Mr. Gessler, we just wait a minute. You may proceed, thank you.
Sure. So you've been on the witness stand before, correct, in the Georgia case, if I
Yes.
remember correctly? Okay. Have you been a witness in any other instances?
No.
Okay. So you know how this works with me asking a few questions. And thank you for being here today. So I want to ask a little bit about sources. You'd agree with me with respect to the 14th Amendment in Section 3 that there's recently, within the past few years, a substantial amount of new scholarship on that issue.
Yes.
Okay. And you mentioned that your view that the Tillman and Blackman viewpoint is in the minority, correct?
Yes.
Okay. And you would agree with me that when courts make decisions on interpretation, they don't count up the number of professors on one side of an issue versus the number of the other side and make their decision on that basis.
Well, no, it's not the only factor.
Well, it's probably not even one factor. They look at the strength and the quality of the underlying arguments, correct?
Yes.
Okay. Now, you and I had chatted just very briefly, and you're familiar with Professor Blackman, correct?
Yes, I know him and I like him.
And you two have mutual admiration for one another and mutual respect for one another's scholarship.
Yes.
Okay. And you still have some pretty sharp disagreements on the meaning and application of Section 3. Is that fair to say?
Yes.
Okay. And it's fair to say that you two will continue to have discussions, continue to disagree, perhaps sometimes resolve your disagreements as part of the scholarly and analytical process.
Probably later today.
He may even be listening to your testimony today.
Could be.
Okay. And then you'd agree with me that that scholars such as yourself and others will continue to analyze the historical record and sometimes modify your opinions based on what you find, correct?
Yes.
Okay. And in fact, there's one instance where Professors Bode and Paulson quoted the historical record of the case of Jefferson Davis. Are you familiar with that?
Yes.
Okay. And Professors Tillman and Blackman looked at the history very closely and said the actual record, this record written with respect to Justice Chase's ruling, was incorrectly recorded. Do you remember that?
Well, they've made the argument that it was incorrectly recorded.
Okay. And so what they did is they compared an 1869 version from an American Law Review to an 1894 version and said, look, the 1894 was essentially that sentence with respect to Section 3 was inserted, we believe, incorrectly.
Well, yes. Now, that's a bit more complicated in the sense that, I mean, first of all, it's not clear that it was inserted incorrectly. Because if you look at newspaper commentary at the time, I mean, there was somewhat of a mixed set of views about what Chief Justice Chase was saying in that case or thought about it. Secondly, it was actually pretty common practice back then for comments to be inserted in official reports years after the fact. In my book on Bushrod, Washington, he would revise his reports, or he had someone who helped him edit them, years after the fact to change them. And so today, they didn't have an official set of reporting systems the way we do now, right? So today that would seem, well, improper or very odd, whereas back then it was more common. So yes, but they've made that argument as you described.
And so the point I'm trying to make, and I'm assuming you will agree with me, but I'll ask you if you agree with me, that there's still substantial debate about the accuracy or the quality of the historical record in some instances with respect to Section 3.
Yes.
Okay. And you'd agree that you have a pronounced point of view and some other scholars have different points of view on that issue?
Yes.
Okay. Now, my understanding is that you have not rendered an opinion, nor have you been asked to render an opinion on the meaning of the word incitement.
That's correct.
Okay, or incite, or any variant of that.
Right.
And so your argument is that insurrection can include words of incitement.
Yes.
But you're not necessarily defining what incitement is.
Correct. I'm not a First Amendment expert.
Okay. Excuse me one moment. Could you hand out one or two, please? And is it, just to understand sort of your definition of insurrection, in order to engage in insurrection, in your view, that requires does that require an overt and voluntary act?
Well, an overt or voluntary act would constitute engaging in insurrection. I mean, whether inaction was just not something that was addressed, so the history doesn't tell us the answer to that.
Okay. Could someone engage in insurrection with an involuntary act?
No.
Okay. Could someone engage in insurrection with a secret act?
Well, no, in the sense that there had to be some public action that was involved, probably, in the sense that there was a public use for, or public purpose to the insurrection.
Okay.
Yeah, I would tend to think not.
So you'd agree with me that it requires an overt and voluntary act?
Well, an overt and voluntary act would qualify, yes.
Okay. And that someone has to have a specific intent?
Well, that's a question on which the sources don't give us a clear answer. The Attorney General's opinions do refer to intent. On the other hand, the cases don't. The cases, to some degree, could be understood as saying that awareness or knowledge is sufficient. The reason I say that is because, let's say you had a sheriff, okay, in a southern state. They were the sheriff before the Civil War. They maintained the same position during the Civil War and after the Civil War. So they're doing the same job the whole time. All that's changed is, you know, they were under the United States, they were under the Confederacy, they're under the United States. It's not clear there if there's any intent involved, but they would have been disqualified because they had served prior to the war, now they're serving during the war, now they're still there after the war. It is clear that they were aware of the insurrection, right? But they were just doing the same job in the same way. So it's less clear that that would constitute intent.
So let me ask you, because there's a couple branches of Section 3, right? There's the aid and comfort to the enemy's branch, and there's the engage in insurrection or rebellion.
Yes.
Okay. So are you saying it's unclear whether or not that sheriff engaged in insurrection?
No, that sheriff was deemed to have engaged in insurrection.
Okay.
My point was that you can't say that there's any specific intent involved there that we know of.
Because he was exercising civil authority under the government of the Confederacy.
In the same way that he did before and afterwards, yes.
Okay. Are you familiar with Professor Kurt Lash? Well, you are familiar with Professor Kurt Lash. You two have, I think, either written an article together or served on a panel?
We did a podcast together, yes.
Okay. And he recently wrote an article sort of talking about the historical record of Section 3, correct?
Yes.
And you agree with me that he uncovered some aspects or some items within the historical record that were relatively new to scholarship?
Well, yeah, I think every draft paper is able to do that, yes.
And that's just part of the advancement of scholarship. Each draft paper adds new information.
Right.
Okay. And have you been in correspondence or spoken with Professor Lash since he wrote his paper?
I have, yes.
Okay. And that's a collegial relationship similar to the one you share with Professors Tillman and Blackman. Would that be fair to say?
Yes.
Okay. Could you excuse me 1 second, Your Honor? Let me just ask you one more question, or just another set of questions on the First Amendment issues. The word within sight. So did I correctly hear it saying that you're not here today as an expert on the First Amendment?
Correct.
Okay. So you've not, for purposes of today, maybe at some other point, sort of done an analysis of what incitement means or the historical record behind
No, I
that?
mean, there were no First Amendment cases from the Supreme Court until well after Reconstruction. So that's part of the reason why.
Okay. So basically, the historical record you've looked at predates modern First Amendment law?
Correct.
Okay. All right. I have no further questions. Thank you very much.
Any redirect?
Very briefly, Your Honor. You were asked about Professor Kurt Lash. Do you remember that?
Yes.
Have you reviewed Professor Lash's draft paper on Section 3?
Yes.
Can you tell us whether anything in that draft paper changed or affected your opinion on what insurrection would have been understood to mean at the time of Reconstruction?
No. He didn't really address that very much.
Can you tell us whether or not anything in Professor Lash's paper changed your opinion as to what kinds of conduct was sufficient to have engaged in insurrection?
No, he didn't really address that much either.
Can you talk to us just very briefly about what the time period was that Professor Lash looked at?
Well, I mean, he was mostly looking at 1866 to 1868, although he did talk about a few other things, including the Horace Greeley example that Professor Delahunty also referred to in his expert report.
Can you tell us whether or not, in your opinion, the time period he looked at in his article was sort of the whole body of historical evidence?
Well, I mean, mostly, but not identically, right? That is, in other words, the time period that we're really all looking at is pretty much between 1865 and 1872, when Congress passed the general amnesty. I mean, there may be one or two things after that, but very little. So his paper covers, much of that period, though not, I would say, not certain things that came kind of towards the latter end of that period.
Thank you, Your Honor.
Does the Colorado Republican Party have any questions for Professor Magliocca?
We have no questions. Thank you.
No questions from the Secretary.
Okay. Professor Magliocca, thank you so much for your testimony.
Thank you.
Good morning, Your Honor. Our next witness is Hillary Rudy, and she is not in the courtroom yet. She is walking over at this very moment.
Okay, why don't we take our break then a little bit early and reconvene at 10:15.
Okay, thank you.